But we begin tonight with the continued efforts by a Trump-appointed judge to defy legal norms in order to show deference to the man who put her on the bench. Of course, I'm referring to one Judge Aileen Cannon, who for a third day now has decided to give Donald Trump and his lawyers a forum to put on his newest form of a reality show in his attempts to either throw out his federal classified documents case altogether or, at minimum, chip away at the heaping piles of evidence prosecutors will be able to use if a trial were ever to be scheduled. It is no surprise that Trump has filed motion after motion in this case. That is his right to do. But the fact that Cannon has been willing to entertain everyone ad nauseum, even when there is little legal or evidentiary basis, only further confirms the appearance that the delay is the point. Remember, there is still no trial date, thanks to Judge Cannon, which means there are no firm deadlines in place to resolve the remaining issues. In today's episode, Trump's lawyers tried to make the case that the original search warrant used for Mar-a-Lago in 2022, which was approved by the magistrate judge under Judge Cannon, was not valid and should be tossed out, along with more than 100 documents marked classified that were collected. Even more consequential was their other argument that all of those damning notes from Trump's lawyer, Evan Corcoran, that point out Trump's clear intent to obstruct justice and stalling on turning over those classified documents should also be tossed out under attorney-client privilege, even though a federal judge in Washington, D.C. already ruled that Corcoran's contemporaneous notes were admissible because of what is known as the crime-fraud exception, that overrules attorney-client privilege if what was discussed was in pursuit of committing a crime, like, say, obstruction of justice. We've already seen what those notes look like throughout the indictment, where it refers to Trump attorney number one, who has been identified as Corcoran. There is this part where they're discussing what to do about the FBI's subpoena request for the classified documents. Quote, Trump, in sum and substance, made the following statements, among others, as memorialized by Trump attorney number one. A, I don't want anybody looking. I don't want anybody looking through my boxes. I really don't. I don't want you looking through my boxes. B, well, what happens if we just don't respond at all or don't play ball with them? C, wouldn't it be better if we just told them we didn't have anything here? And D, well, look, isn't it better if there are no documents? And then there's also this beauty when discussing what documents they should ultimately turn over. Quote, during that conversation, Trump made a plucking motion as memorialized by Trump attorney number one. He made a funny motion as though, well, OK, why don't you just take them with you to your hotel room? And if there's anything really bad in there, like, pluck it out. And that was the motion that he made. He didn't say that. No wonder Trump's lawyers want to get those thrown out. And that's just part of it. New reporting on those notes from ABC News, who said they have reviewed the records, claims to show that Trump privately expressed concerns that turning over those classified documents after receiving the subpoena could result in criminal charges, while Trump continued to try to get his lawyers to lie and destroy documents for his benefit. Quote, he raised a question as to if we gave them additional documents now, would they, the Department of Justice, come back and say, well, why did you withhold them, and try to use that as a basis for criminal liability or to make him look bad in the press, according to Corcoran's notes. And yet, with all of these matters having already been decided by other judges, Judge Cannon has again felt the need to burn through a lot of time on Trump's behalf. And today we are again no closer to beginning a trial that Trump knows he cannot win. Joining me now is Barbara McQuade, former U.S. attorney, professor at the University of Michigan Law School and MSNBC legal analyst, and Mary McCord, former acting assistant attorney general for national security and co-host of the Prosecuting Donald Trump podcast. Thank you, ladies, both for being here. I'm going to start with you, Mary, here at the table. Is there any world in which that search warrant is invalid? And can you imagine why a judge would hold an entire hearing on that question?
I don't think there's any world based on the arguments that were made. And actually, some of the reporting out of the courtroom does seem that Judge Cannon actually was also skeptical of Trump's arguments. He made arguments in two flavors. One was that he was entitled to what's called a Franks hearing, named after a case called Franks v. Delaware, that says if there are recklessly misleading facts or omissions, or not facts, recklessly misleading information or omissions in a search warrant, and if without those there would not have been probable cause, then the entire, the evidence seized as pursuant to the search warrant can be suppressed. And he wanted to have a hearing on that and hear from agents about that search warrant.
Sure.
But the things he said were reckless omissions, were things like not saying in the search warrant that within the FBI, there were some people that thought they should ask for consent rather than do a search warrant. So what?
Right.
That has nothing to do with probable cause.
Yeah.
Things like explaining in the search warrant that when he was president, he was held a top secret clearance, and he held clearances and was able to be briefed on top secret information at Mar-a-Lago. So what? This is all post-presidency. And the reporting I saw some from out of the courtroom is that Judge Cannon at one point sort of also said, so what? Aren't we now talking about post-presidency? So I do have some optimism on the search warrant question. The other basis was that it was too broad. It allowed for a search of too many places. And Judge Cannon at some point said, well, if nothing was seized from some of the places you think that were not particularized in the warrant, then what's your harm?
Right.
And
he
didn't really have a response.
As response to that. And Barb, I mean, the things that Trump's lawyers seem to be bringing up are things like when they unpacked the boxes, they didn't put things back in the box exactly in the order they were in. If they were next to an old People magazine with Trump's face on the cover, it should have gone right back next to the People magazine. If they were next to some dirty drawers or a shirt in one of the other boxes where, again, classified documents shouldn't have been in the first place, well, if they didn't put it back next to the dirty drawers, then those are the kind of arguments they were making. Is there any world in which that is a reasonable argument as to why a search should be thrown out?
No, and in fact, with regard to this particular argument, Joy, they're asking not just that the evidence be suppressed, but the whole case be dismissed, suggesting that there is something nefarious going on about all of this. No, this is an issue that certainly the defense can raise on cross-examination. I don't know why it would matter whether the classified document was before or after the Christmas card that he had saved from some fan who had written him. But, to the extent it suggests that perhaps it was hidden behind another document and it was difficult for him to see, I don't think that's going to square up with the other evidence that we have seen about the obstruction and some of the other things. But that's an argument that the defense can make at trial for the jury, but it's not a basis for suppressing the evidence in advance of trial.
And see, that is the at trial is the thing to me that is the key point there. These sound like the things that should be litigated as part of a case that's happening. It seems that Judge Aileen Cannon is interested in having all sorts of hearings about all sorts of ephemeral issues regarding whether or not the trial should ever happen at all. What she's not interested in doing is starting the trial.
Or ruling on some of the motions.
Right. She's just listening to them like she's sort of in judge school and like listening to all these interesting arguments and taking her time and then not deciding anything. Is there any way for Jack Smith's office to force her to start this trial?
Not really. I mean, the trial judge has control of their own calendar. I mean, there's been a lot of talk about will one of these opinions, if she ever issues a ruling, be appealable. And several that she heard in fact, everything she's heard these last 3 days, a negative decision would be appealable by Jack Smith. So if she were to dismiss the case on the grounds that the special counsel wasn't properly appointed under the Constitution, or if she were to dismiss it on the grounds that the funding for the special counsel doesn't come from the right bucket of funding, that would be appealable. If she were to deny the motion to modify the conditions of release to prevent Mr. Trump from saying things that cause a significant imminent risk of danger to law enforcement, they can appeal that. And if she were to suppress evidence pursuant to the suppression motion, and that includes Evan Corcoran's notes, that would also be appealable. So these all might give depending on the ruling, give the special counsel the chance to go up to the 11th Circuit and seek a reversal, which just depending on the circumstances may or may not be a chance for them to seek a recusal. People ask about that all the time. The government is loath to seek a recusal.
But Barb, you've had all this. I mean, the Wall Street Journal, for God's sakes, has got such new information about just how many doubts the judges, the senior judge in her same circuit had about her, whether she should stay on the case. And then you add to that dragging her feet. There has been this talk of a writ of mandamus. Like, could Jack Smith file such a writ and essentially demand that a court higher than her order the start to the trial? Is that something that you cannot see happening?
Not yet. I mean, it is a possibility because, one important consideration is that it is not just the defendant, but also the public that has a right to a speedy trial. Under the Federal Speedy Trial Act, while all these motions were pending, the clock was stopped. She now has, now that she's held a hearing, 30 days to issue decisions on these. Now, there are provisions under even the Speedy Trial Act to extend that for issues of complexity, and in this kind of case, she probably could do that. But at some point, if she simply fails to rule on these motions or set a trial date, that could be a basis for seeking a writ of mandamus, which is really just a request for the higher court to say to the district judge, make a decision, do your job. The time has come. You can't wait anymore. You know, again, just as Mary said, the government is loath to request a recusal. I think the government is also loath to request a writ of mandamus. It is supposed to be granted under only rare circumstances. But at some point, that is a card that the government can play if the judge continues to delay in making decisions.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.